got a few on the docket, so what I'm going to do is I'm going to call the cases and see who's here, so I know which I can proceed on. But before we begin, I do want to bring to everyone's attention that I am live streaming today's proceedings on YouTube. Because all of you had to have a password to access today's proceedings. Obviously, there's no public access otherwise. The solution we came up with is a live stream. I'm letting you know this because, hey, I just want to disclose that it's happening, but also I don't want anyone to have the impression that this is creating some sort of a record. You still have to bring a court reporter if you want a record. The live stream will be deleted immediately upon the conclusion of today's proceedings. All right. So I've got 17 SC 660 Naples HMA versus Curtis Collins. Do I have counsel for Naples HMA?
Yes, Sarah Jordan for Naples HMA.
Good morning. Are you also here on 20 SC 21?
Versus Jeremy Sternangle, yes.
Yes. All right. And let's see. Got Daniel Larson versus James Massa, 20 SC 3207. Mr. Larson, good morning.
Yes, I'm here.
And Mr. Walters, are you here on behalf of James Massa?
That is correct, Your Honor.
Very good. And then let's see. So do I have either Jeremy Sternagel or Curtis Collins present? If someone signed in under Florencia Engel, go ahead and unmute. Which case are you here for? Someone logged in under Florencia Engel. Please go ahead and unmute. I don't...
Yes, good morning, Judge. I am sorry, I am Florencia Engel. I'm representing Wells Fargo on Wells Fargo versus Jeb.
All right.
And I just wanted to notify you, Judge, I'm sorry, I'm driving on 95 North. There was an accident. I was not able to exit to make the call, but that case has settled. I don't know if you want me to go back in 20 minutes to appear properly, I can do that.
No. Are you choosing? You're just telling me you're not going to proceed on the motion for summary judgment at this time?
No, we're not, because the case, we have a stipulation that the defendant will sign. So we're going to continue that. And I believe it was also set for trial. So we wanted that canceled as well.
No problem. I'll make sure that gets taken care of. Just file your notice of settlement and along with the proposed settlement in order. Okay. Okay.
Thank you, Judge. I appreciate it. And I apologize.
No, thank you. Drive safely. Okay.
Okay. Thank you, Judge.
All right. Take care. Bye-bye. All right. So one moment. Let me just mark that. All right. So let me go ahead and address, because I do have both parties present. Ms. Jordan, I appreciate your patience, but let me just see if the defendants on your cases, give them a couple minutes, see if they might appear, okay? All right, so let me address Mr. Larson and Mr. Walters. This is 20 SC 3207. This is the defendant's motion to dismiss. I did have an opportunity to review the motion as well as Mr. Larson's response. Mr. Larson, go ahead and unmute, please. All right. Are both parties ready to proceed?
Yes, we are, Your Honor.
Yes.
All right. This is the defendant's motion. So counsel, whenever you're ready.
Thanks very much, Your Honor. Good morning. Theodore Walters for James W. Massa. The basis for the motion to dismiss, Your Honor, is quite simple. The plaintiff has sued the wrong person. The plaintiff has sued James W. Massa in his individual capacity. However, all of the allegations of the complaint arise from Dr. Massa's dental practice here in Naples. Dr. Massa operates his dental practice through a Florida professional corporation, and that would have been the proper party to sue. The statement of claim actually admits this. It says that the matters relate solely pertaining to the dental practice and not to Dr. Massa in his personal capacity. There's a statement that Mr. Larson made in his statement of claim where he says, I sue as individuals, not a corporation or other entity, as I can find no entity, Massa Dental Center, registered with the Division of Corporations. Yet there is one. It's not called Massa Dental Center, but it is James W. Massa DDS PA. So the statement of claim really does need to be dismissed because it was simply brought against the wrong party. This is also addressed in the motion to dismiss motion that Mr. Larson filed. He also admits there that the matter is a professional dental issue arising from Dr. Massa's dental office and arises from his capacity as a dentist. So bringing the case against James W. Massa in his individual capacity when there are no allegations that pertain to him as an individual is incorrect, and we respectfully request that the court dismiss the motion with prejudice.
Well, my only question would be then, would it not be appropriate if I were to grant your motion to do it without prejudice and leave to amend to name the proper party?
Well, I think, Your Honor, as far as James W. Massa in his individual capacity, I do think it's correct to dismiss that with prejudice because, again, there are no allegations against him personally. I think it's more than an amendment, however. I think this case needs to be dismissed and a new case brought. I don't think he can amend it to add a party defendant.
I understand. All right.
Thanks,
Mr.
Your
Larson? Mr. Larson, your response? Please?
Yeah. Well, my position is also quite simple. Yes, it is accurate that the reason I brought the motion the way I did is because I could not find a registry that he was an owner of. When that information was presented by this counsel, I responded by stating, look, he is still liable for this company. Making this distinction is Dr. Mesa cannot run this business without his personal dental license. He saw me in the capacity of his dental license. He would not have been in a position to charge me for a device that he never provided had he not personally been a dentist who owned this business.
All right. One moment. All right. Given the nature of your complaint, Mr. Larson, it's a disagreement over a service provided, in particular, a refund that you feel you're entitled to. A refund would come from the corporation, which would be James W. Massa DDS PA. Is that correct? Is that Mr. Walter, that's the name of the corporation?
That is correct, Your Honor.
The whole purpose, Mr. Larson, of the formation of a corporation is exactly this, is to shield individuals from personal liability under circumstances where their business is acting in a certain way. That is one of the primary functions of a corporation, is that the individual owners are not personally liable for the actions of the corporation.
And I understand that.
In this case, your dispute is with the company. The dental practice of Dr. Massa, not him personally.
Yeah.
And because he wasn't acting he wasn't acting as an individual. He's acting as a employee, if you will, or agent of the corporation. Under the circumstances in this case, the motion to dismiss is granted. There's nothing about this that stops you, sir, from refiling a new case against James W. Massa DDS PA, right? And then you can bring your claim that way, but you have to bring against the appropriate party. Under the law, the dental practice is its own separate entity as much as a human being is for these types of purposes, okay?
Understood.
So, counsel, you'll prepare me a proposed order then?
I will do that, Your Honor.
And against, Dr. Massa, in his personal capacity, the motion dismissed with prejudice is granted. Mr. Larson, you are free at any point to refile your claim against the dental practice and bring your case in that way, okay?
Thank you.
All right, thank you.
Your Honor, may I email the proposed order to Chambers,
Yes.
or is
Yes,
that
sir.
acceptable?
Yes, sir. You can email it to my judicial assistant. Do you have her? Do you have her email address?
I'm sure I can find it on the website.
Very good. Yeah, please email it to her in Word format, and I'll get that. I'll get that filed. All right.
Thank you, Your Honor.
All right.
Thank you, Your Honor.
Appreciate it.
Take care.
You too.
All right. Counsel, I appreciate your patience. Let's go ahead and address your cases. So let me start with the easy. Well, I guess this is the easy one. This is 17 SC 660 Naples HMA LLC versus Curtis Collins. A while back, there was a motion for contempt, which was granted.
Yes.
And I had issued an order to show cause, I believe. And part of it required the attendance of the defendant at a deposition.
Mm-hmm.
But the proposed order with the date came subsequent to the date of the actual deposition that was set. So I was reluctant to sign that order to potentially hold someone in contempt for a date that had already passed.
Understandable.
So I communicated that to your office, and I got a new proposed order that just said with a date to be set in the future. And that makes me a little uncomfortable too, because I'm not prepared to incarcerate somebody on a contempt order if we don't really make it explicitly clear where they need to be and when.
Okay.
And so I said, I just wanted to set this just so I could make it clear what my position was, especially with the slim hopes that Mr. Collins would show up, so I could just tell him to his face,
Right.
please go to the depot, get it done so we can be done with this business. That didn't happen, but if you can give me a new order with a specific date of a deposition that's set, and please do it far enough in the future, because I am insistent that we obtain personal service on somebody before I'm willing to hold them in contempt.
If I may, Your Honor, I went back and reviewed all of the notes on this case, and it appears that sometime between the hearing and the order, I'm not sure if it was between the hearing and the order being filed, we actually obtained work information on the defendant and were seeking to garnish.
Okay.
So we weren't necessarily, I think we had filed a withdrawal of our contempt motion because we did not need to proceed in that manner anymore.
I never got the withdrawal.
Okay. So that would be the problem.
Right. Well, that takes care of that.
Yeah.
Perfect. Well, that was even easier. All right. Please just file that, and then we're in good shape.
File the motion to withdraw?
Yes, please.
Okay, sure.
All right, and that leaves us with the motion for summary judgment.
Yes, Your Honor. Okay.
Yes, ma'am. Go ahead.
So this defendant had originally answered pro se and filed a counterclaim to the to our complaint, stating that he had, I guess, received poor care at my client's facility.
Right.
We sought a motion to dismiss or motion to strike the counterclaim, which she did grant without prejudice. And
no refiled counterclaim, I don't believe.
right.
Okay.
So we're here today seeking a motion for summary disposition because the defendant did state in his answer that he received the services, therefore admitting liability. And since this is simply a matter of money owed and not the level of care received, we would ask for a judgment against the defendant.
All right, let me just make sure that the notice went out appropriately. The notice went out on February 1st. Today's 22nd, had the Zoom codes on it.
Mhm.
No, I received notice for today. Have you gotten a return as unserved notice for today? So before I proceed.
Looking for service.
And Cypress C, apartment 201. This is the same address as we sent notice for the last hearing, which they attended, I believe.
I think we just mailed it to them. I don't think we did a.
No, I wouldn't expect you to do a process server. I just wanted to see if it was mailed and whether or not it was returned, if the address that we've been using is still good.
I don't see any return mail in here.
Okay.
I'll double check the notes on it. Oh, we did receive an updated address from the postmaster, but we did resend everything to
Okay.
the new address. It was only
When was that? When was
a
that?
week ago.
A week ago?
On the 15th, we remailed everything.
Well, that's a concern only because I can tell you we've had problems with the mail being slow lately.
Yeah. I mean, if your honor wants to reset the hearing, I don't think that will be an issue. Just
If you don't mind, I just like to make sure they got notice because they have been participatory in the proceedings.
yes.
So let's just reset with enough notice. If you want, I can step away for a moment and get my judicial assistant to give you a date right now.
Okay.
If that's more convenient, or you can have your office to schedule with her later, whatever's easier for you.
Oh, we can schedule it with her later.
Okay. All
Yeah,
right.
no worries.
All right. So we're into, not heard, because of, I don't want to say, non-service, we just don't know.
Yeah, I understand.
And if you're willing to reschedule, that'd be great.
No problem.
All right. Well, I think that does it for us today.
It sure does. Thank you so much for your
Thank you,
time.
counsel. Have a great day.
You
Take care.
too. Bye-bye.